Once an issue is actually litigated and decided on the merits by a court, that issue may not be litigated a second time, even if done later as part of an unrelated lawsuit. Unlike res judicata, collateral estoppel only applies to issues actually litigated and decided by the court. In one sense, collateral estoppel is more narrow than res judicata. If you recall, we said that res judicata bars all claims that could have been brought pursuant to the transaction or occurrence that underlies the case. Collateral estoppel is limited explicitly to issues that were actually litigated. But collateral estoppel is also more broad than res judicata. It bars the relitigation of issues even if the prior litigation and the current litigation did not arise out of the same transaction or occurrence. Indeed, even if they are otherwise completely unrelated. Let's use an example to illustrate. Paul and Deborah have a contract dispute. Paul sues Deborah for breach of contract. Deborah defends by saying that the contract was in fact fraudulently induced. She loses. The court determines that in fact the contract was not fraudulently induced. 3 months later, Paul comes and tries to collect. She sues for an injunction preventing the collection, claiming that she complied with the terms of the contract. That's res judicata. If she wanted to argue that she complied with the terms of the contract and therefore there wasn't breach, she should have done so when Paul sued her for breach of contract. The court found that she breached the contract, and that decision was final regardless of whether or not she presented evidence to the contrary. 5 years later, Paul and Deborah now get into a copyright dispute. Paul sues on the grounds that Deborah has misappropriated his intellectual property. Deborah counters that she developed the intellectual property independently, and in fact before Paul did, and that Paul is the misappropriator. Paul pulls out the contract from the prior litigation and points to some language in that contract that demonstrates that the intellectual property was his at the time of the contract, some 5 years ago, and before Deborah claims to have developed it independently. Deborah again says that the contract proves nothing because it was fraudulently induced. This time she's up against collateral estoppel. Note that the current litigation is about intellectual property, not the contract. This case and the prior case do not arise out of the same transaction or occurrence. But Deborah seeks to relitigate an issue that was decided by the prior court, that is, whether or not the contract was fraudulently induced. The prior court said that it wasn't, and that's the rule going forward. The contract was not fraudulently induced. She cannot now use that argument in this new unrelated litigation. Now, the issue in collateral estoppel need not be a claim or affirmative defense. It can be, and often is, a single fact decided by a prior court. However, in order for collateral estoppel to be applicable, the issue must have been essential to or necessary to support the judgment in the prior litigation. If the issue was simply an auxiliary point that the litigants might not have spent a lot of time or energy on, knowing that it wasn't really that important in the prior litigation, or was not implicated by the prior judgment, perhaps even if they thought maybe it was important, but it wasn't compelled by the prior judgment, collateral estoppel will not apply. Now, if you're faced with a prior judgment that implies the issue in your current litigation but doesn't decide it directly, be very wary. You can have collateral estoppel by implication, but if there's any other way to read the prior judgment that does not get to your issue in the current litigation, you should interpret the prior judgment so as not to reach the issue in the current litigation. It's going to be fairly rare, or you need a fairly crafty exam drafter, to come up with a case where collateral estoppel by implication is actually going to work, where the prior judgment very clearly implicates the issue at hand, even though it doesn't say so explicitly. The issue in the prior litigation and subsequent litigation must be materially identical. If they are similar or closely related, but different in some significant way, for example, we have two different contracts using materially the same terms, but they're different contracts, collateral estoppel is not going to apply. The details here can be a bit tricky, but your professor probably is not going to test you on all the nitty-gritties beyond the general principle that the issues must be materially identical. Make your best argument why this is materially identical or not. Going back to our hypo with Paul and Deborah. Assume that the original contract between Paul and Deborah actually was fraudulently induced. Deborah was right all along, but that Deborah was simply not able to produce evidence at the first trial to that effect. It just wasn't available it was available, but she wasn't able to access it for some reason. As a result, she lost on Paul's breach of contract dispute and is now about to lose on his intellectual property dispute. She has now found that evidence. Maybe she hired a better attorney and was able to get to that evidence. She doesn't want to relitigate exactly the same question. She wants to introduce this new evidence, making the question for the court a bit different. It doesn't matter. It's the same issue. New evidence, slightly different question, same issue. Collateral estoppel is going to bar the court from taking it up as long as the evidence was technically available to her previously. If the evidence wasn't available before, it didn't exist, or she really had no access to it, it was protected by some law, equity will likely require us to let the latter court hear the new evidence. Collateral estoppel will not apply. But where's the fairness in the first result, the total ban, even if it seems clear that the first decision was a mistake, and due to no fault of the client's own? Perhaps it was due to the attorney or an agent or some other party that she couldn't access the evidence and enter it into court. Or even if it was her own mistake, but it was a technical glitch and she messed up when trying to present the evidence. The purpose of collateral estoppel is to preserve resources by preventing relitigation of the same issues. It's not fair to the other party, Paul in this case, or the judicial system at large, to relitigate the same thing multiple times. After all, litigation must end at some point. If evidence is available at the time of the original trial, you have to use it. And the fact that she couldn't, that's not Paul's problem. And as an aside, Deborah might have a malpractice action against a prior attorney or might have other ways of protecting herself going forward, but relitigating the prior issue is not going to be one of them. To give you another example, a defendant in a criminal trial is found guilty of a crime that has multiple elements. A finding on each of the elements is essential to the underlying judgment. Even if the court's judgment doesn't actually specify each of the elements, it's clear from the court's holding that it found each of the elements and they're all there. So let's say that in an aggravated battery case, the defendant is found guilty, and one of the elements of aggravated battery in our state is that he used force against the victim. In the subsequent civil trial between the victim and the defendant will now not be able to argue that he didn't use force against the victim. That was found in the criminal trial. The two issues are identical, even though the claims in which they appear are not. Be wary of standard of review, however. It doesn't work the other way. You can't use a finding in a civil case as collateral estoppel in a criminal case, because the standard of evidence, standard of review is much higher in criminal law. If the substantive law goes through a major change that essentially overruled the prior case, collateral estoppel will not apply. So to return to our hypo with Paul and Deborah, if the prior court found the contract to be non-fraudulent, but that finding was based on a common law understanding of fraud, and then in the interim, let's say this was 10 years ago, the state doctrine on fraud changed, calling into question all of the prior holdings on fraud. Now, you're not going to be able to relitigate the prior question relating to contract. That's going to be res judicata. But Deborah will be able to raise the fraud issue again in her subsequent intellectual property dispute, because the prior holding has been called into question by a significant change in law. This is pretty rare. Something as significant as getting rid of a common law understanding of fraud would apply. One final point. Collateral estoppel typically applies against the same parties to litigation or people in privity with those parties, such as successors in contract, if those in privity are closely related with the underlying deal. We explained privity when we discussed res judicata. However, unlike res judicata, collateral estoppel can be used as a shield by new litigants, that is, people who were not party to the first litigation, to fight off claims by litigants in the prior litigation who already had their day in court. A new party can use collateral estoppel to defend themselves against somebody who's already addressed this issue in a prior litigation and lost on it. Not only that, collateral estoppel can sometimes even be used as a sword by a new plaintiff against a defendant who was party to the prior litigation. For example, if John sues Mike for slander and wins, I might be able to use collateral estoppel against Mike, that is taking advantage of John's victory against Mike, and get judgment against Mike without ever having to litigate the issue, as long as I can show that my situation and John's are identical enough to satisfy the requirements of collateral estoppel. Now, this rule has a lot of exceptions to ensure fairness, and it should not be surprising that we are very reluctant to use it. We're very, very reluctant to use collateral estoppel when evoked by somebody who was not a party to the prior litigation. And we won't do so if there's any question at all that the loser in the prior litigation did not have a full and fair chance to address the issue, or if there is some material difference between this trial and the prior one. Additionally, When a new plaintiff comes in, let's take me for example in the prior hypo, and wants to use collateral estoppel as a sword against an old defendant, we are not going to let him if it appears to the court that the new plaintiff was waiting in the wings, waiting for an opportunity to jump in and strike at the defendant. If the person who wishes to use collateral estoppel as a sword had the opportunity to enter the prior litigation and chooses not to, hoping that the other parties will fight it out and create a favorable verdict for the person who wants it, no collateral estoppel for you. You have to litigate the hard way just like everyone else.